versus
Justin Gamboa.
what's the charge?
DWI second.
Yep.
Offense date? Alleged?
Hold on 1 second. It's 5/31/19. May 31st.
All right. Mr. Wilson, you're gonna have Mr. Gamboa testify?
No, Your Honor, these are simple motions for discovery.
I understand, but since he's present and I never know what people are gonna do or say, I will put him under oath if he's gonna testify, otherwise I'm not.
I do not plan to put him on testimony.
Okay, I wouldn't think so, but stranger things have happened.
I'm sure.
Yeah, here, let me splash my feet a little bit on the water here. Don't I wish? Kayleen, how are you?
Good, sir. Thank you. How are you?
So far, thank God.
Which
Virtually,
motion are y'all gonna hear first, Judge?
let's go with the Discovery 39.14A. This is just a general discovery motion. Is there anything specifically that you're asking for, Mr. Wilson?
Yes, Your Honor. I want it granted, but I want a date by which the state has to comply, or a date by which, after which the state can't bring any further evidence, because I do plan in this case, probably, unless I get further evidence, to bring a motion to suppress.
Motion for discovery.
I got it.
Thank you.
So I would like a date by which the state has to say they are complete or done, and so I can bring my motion for suppression after that.
Well, aren't we usually the constraints are at least 20 to 30 days before trial?
Maybe.
Hello,
Your Honor, can you hear me?
I do.
Okay. Was that question directed to the state or to the defense, Your Honor?
Both.
Okay. Well, the state would say no. It's not limited to 20 days before trial. What is limited to 20 days, no later than 20 days before trial, is a expert witness list per 3914. But it's as soon as practicable to turn over per in response to an affirmative request from the defense, the discovery covered by 3914. So no, sir, there's no set time limit by statute for the other information in 3914, with the exception of the expert witness list.
All right. So then we're not constrained to give you a deadline by which to comply. Is that what you're saying?
That's correct, Your Honor. Not as far as a at the latest date, Your Honor. That's correct. That's an accurate assessment of 3914.
All right.
Your Honor, I believe what I'm saying here is I don't want to waste the court's time. I'm ready right now to write and file a motion to suppress this case. I don't know when it's going to be heard, when we can get back to court and call a jury.
I understand that.
So we
can hold a motion to suppress basically at your convenience, because we're holding, as we're doing right now this moment, we're holding our pretrial hearings by remote, unless there's an objection, which is I have yet to have one that refuses to accept the pretrial hearings.
Well, that's the problem. I'm looking for a deadline date. If I bring a motion to suppress and I show that there's a problem, the state might come back to you and say, oh, well, I'll just supplement discovery. And I don't want to waste the court's time with that. What I'd like is a deadline by which their evidence is going to be in, and then I can bring to you, here's their complete evidence, and this is what I'm saying is here's my suppression issue. If we don't give them a deadline, then the state will tell you that, oh, I need further time, and there's no deadline by which they can bring evidence. So I'm just looking, this motion is typically signed. We give the state plenty of time to give me all their evidence. And then at the end of that, I can decide if I want to bring a motion to suppress or just go to trial. And so I'm just asking for a deadline so that I can bring to you a motion to suppress that will probably get rid of this case, in my opinion. But I can't do that until I know that the state has completed their discovery, giving me everything. And that's all I'm asking for, a deadline there. And that I'm not sure if the state is saying that you cannot give them a deadline, because you absolutely can. And this case is approaching a year. I'm sure they've given me everything. I just can't tell you they've given me everything.
And
Your Honor, may I respond?
your basic position is that absent a deadline, you cannot submit a motion to suppress because they can always amend. Well,
Exactly.
What would stop them from doing that anyway? Even if I give them a deadline, what stops them from asking permission to submit evidence before trial?
Nothing's going to stop them from asking. I would think that the court would say, well, what, were you just going to hide this evidence until, indefinitely? At what point are they not allowed to bring in new evidence? Are they allowed to bring in new evidence that they did not want to disclose to me, but I poke a hole in their case during trial? I'm just saying there has to be a deadline here, and I'm asking for it. I typically get this motion signed with a deadline regularly. Because of that exact problem. Give them plenty of time. I'm not saying don't give them time. Give them plenty of time. But at some point, they have to say, this is all our evidence that we're going to come to trial.
Now, Your Honor, may I respond?
Yes, you may.
The deadlines typically work backwards from the date of trial, and this case is not on the trial docket yet. We would have to work back from the trial date if the defense wants to put it on the trial docket, and then we'll have a date to work back from if he wants a deadline in that regard. Hence the statutory deadline for expert witness lists per 3914, working no later than 20 days prior to the date of trial. And so if that's the defense's contention that he wants to put it on the trial docket so that we can work from a deadline, then that's his prerogative, that's his client's prerogative. But of course, the state does have an affirmative duty to turn over Brady evidence as well, regardless of time and regardless of when that evidence crosses our desk, or when we're able to find that evidence, or when we're able to locate any such evidence of Brady. So I don't understand the blanket request for a deadline to turn over any discovery to the defense, as we have a continuing obligation to turn over all Brady evidence, an affirmative duty that's not responsive to any request to the defense. And so if he could be clearer on what exactly it is the defense is asking as far as discovery and what.
I hear what you're saying. I'm concerned that the request, Mr. Wilson, is to try to tie them down now and not allow any further evidence further down the line. I've never heard of that.
So let's do this. Put us on the trial docket. All right. Let's get rid of that worry. Set a deadline whenever you're going to set a deadline. Just know that I plan to, as soon as you say they're done bringing new evidence. I understand there's Brady. I'm not worried about things that exonerate my client further. I mean, if they have a duty to do Brady, I mean, that's constitutional. We can't abrogate that. What I'm saying is they can't keep bringing something new as to a new video. Oh, here's another video that shows this deficiency he was talking about. Or here's a witness list, witness statement.
Let's do it this way. Michelle, scroll up a little bit so that the number 1 on there is at the top of the page. That's good. All right. All offense reports, have they been turned over to you? Or at least state, have you turned over all offense reports?
Everything that we have in our possession, Your Honor, we have turned over in Veripic. And if the court will give me a brief couple minutes to bring that up in the digital evidence, I can make sure that all of those are set to discovery. But as per our open file policy, yes, Your Honor, everything has been turned over and uploaded that's within our possession. But I will go ahead and confirm that right now if the court will allow me.
All right, let's go through 1 through 8 here. And we're going to cover this one way or the other to the extent that the court's willing to do that. I don't believe in strapping either side with deadlines that are not based on law. Mr. Wilson, if you show me some kind of a code, something in Code of Criminal Procedure that says that I can place a deadline on either side for whatever restriction that there would be, I'm willing to do it, but I've never heard of it.
Okay.
No,
How much
I
time do
understand.
have for that?
I understand what you're asking for. I'm just not in a hurry to grant it right now. The simpler way is to go through 1 through 8 and see what we got.
Okay. Let's go 1 through 8, but how long do I have to bring you something from the Code of Criminal Procedure?
I'll give you at least 2 weeks, Al.
Okay.
We're not going to get back in here again until your motion for suppress or to suppress.
Sure, absolutely.
All right.
Let's go through 1 through 8. The second one is written and recorded statements of the defendant.
All right, Virgil, have you got your stuff up?
I do, Your Honor. And offense reports have been made available to the defense and have been made available since June 3rd of last year, 2019, Your Honor.
All right, number 2, written and recorded statements of the defendant.
Let's see. Yes, Your Honor, that includes video statements uploaded on March 15th of this year, 2020. That's a BCSO video.
All right, number 3, all written and recorded statements of all witnesses.
That would be in the offense reports. I'm seeing June 3rd, 2019, Your Honor.
All right, number 4, all written statements of all law enforcement officers, in this case, including affidavits.
Yes, Your Honor. That's part of the offense. That's part of the offense report packet made available June 3rd of 2019.
5, all documents, papers, books, accounts, letters, objects, and other tangible things seized from the defendant, his home or his vehicle.
Let's see. I'm not sure. I'm not aware of anything that is still in the state's possession that was seized from the defendant's vehicle, Your Honor. But
are you telling the court that this is this part of your file, and which is open file practice with the DA's office?
yes, Your Honor. Any evidence seized would have been returned. Did the defendant get his vehicle back?
Yes, he has his vehicle.
Okay, and it had everything in his vehicle after being inventoried. Everything in his vehicle, nothing was missing. Correct?
Not that I'm aware of. Would you like me to speak with my client briefly?
Well, yes, yeah. Because if it's in your motion, I'd like to know if there was a specific basis for asking for it. Did you have cause to believe that there was withheld evidence?
Not right now. Let me speak to my client privately for just a moment.
Patty,
Mr. Wilson,
Sure.
let's finish this
Okay.
before you do that. I'll go as far as we can. All photographs, videotapes, that's number 6, audio, and other electronic recordings taken, made, or obtained by agents of the state of Texas during its investigation of this case.
Yes, Your Honor. Electronic recordings, the video from the officers was made available on March 15th, 2020, and that is discoverable and has been turned over since on that date.
Number 7, all books, accounts, letters, cell phone records, text messages, voicemails, emails, social media content, or objects or other tangible things not otherwise privileged that constitute or contain evidence material to any matter involved in the action and that are in the possession, custody, or control of the state or any person under contract with the state.
Yes, Your Honor. I'm not seeing any such category in our evidence.
All right. Obviously, if you discover any, you're going to have to turn it over, and I understand it.
Absolutely, the state recognizes its affirmative duty to turn not only Brady evidence but 3914H Michael Morton evidence, Your Honor, because the state's discovery law, as the court and as the defense is aware, gets rid of the materiality requirement, and the state observes that and recognizes that and will continue to turn that over as it discovers that. Certainly, Your Honor.
All right, and as of right now, whatever you've got, you've turned over with your open record, open file practice.
Correct, Your Honor. And the state, in addition to that, the state will go ahead and just to be sure to also send an inquiry to the agency BCSO to obtain any evidence that may still be in their possession that the prosecution does not have access to. But as of right now, everything in our possession, custody, control that we're aware of has been turned over to the defense. Yes, Your Honor.
All right, number 8, you've answered in response to number 7 also, and you stated it earlier several times already, in fact, that you understand your Brady obligation and you've complied with it and will continue to do so affirmatively.
Correct, Your Honor. In addition, not only Brady evidence but also Michael Morton evidence, as we.
I got you, but number 8 specifically doesn't say the word Brady, but it describes the Brady requirement.
Correct, Your Honor.
All right, Mr. Wilson, this kind of pretty well answers all the 39.14 that I can see or I'm aware of. Yes. And the state is telling you on the record that it's turned over everything to you that it can and that they have possession. And I'm aware that they are acting in good faith by saying this. I have no question or doubt that. I cannot give you a specific deadline. It appears that it's already been complied with and will continue to be complied with, specifically on Brady. But as of right now, I will not give you a deadline date, but I think you're in position to file whatever motion you need to. I'm doubtful that there'll be more evidence that will be produced. If there were, you may then at that point raise an objection of timeliness, or then that they've not complied with Brady or with 39.14, and I would address that at that time. But I can't be that broad as you've asked, not beyond what we've just done.
And Your Honor, I would also add that the state will also inquire with the arresting agency to make sure that there's nothing that is in their possession, in BCSO's possession that we haven't had access to. We will go ahead and do that as a good faith measure to seek out any discovery that may be in their possession that they hadn't forwarded for some reason to us. But the state is not aware of any such evidence and has turned over everything per our open records policy and also per Michael Morton Act and the Brady Discovery Act.
All right. Then, Mr. Wilson, you had the second part of your second motion.
You know, that's a witness list. I'm less concerned about that. I don't know if a witness list was turned over in this case or in a different case. I think it was the divorce case, so it wasn't this case. But I'm, under the analysis you just gave, I'm not going to waste your time. However, this is what I would like to do, Judge, and just being upfront with everybody and considering the judicial resources we have, because these things are expensive. These Zoom hearings are a lot of work by everybody, and it takes away your time from the thing. I want to bring my motion to suppress based on what we've talked about here today. And if we get to a point in my motion to suppress, Judge, where there's evidence that the state says they want to bring more evidence, then I want to use this record to make argument that they cannot. It was that we've talked about here today, that they've turned over everything, and we just went over a specific list. that they've turned over everything. And in my motion to suppress, I'm going to call into question certain things. At that point, if they want to bring something that clearly they should have brought, then I want it excluded. And based on my argument today that I don't want to waste the court's time. I don't want to bring a motion to suppress and have the state say, oh, there's some more evidence.
If and when that arises, I'll address it at that time.
Okay.
I think in under the constraints of our Constitution and laws, at that point, I would have some different choices, including granting you a continuance or anything like that. I will address it at the time if and when that arises.
And for 5, this Michelle.
And I'm not overly concerned. If, in my opinion or observation, you have been treated improperly, that, in my opinion, violates some legal or ethical requirement, I'm not shy about calling it like it is. So we'll do it at that time, but right now it's very preliminary. I'm not going to tie myself down to any particular position on that. But I understand what you're saying. I've been in your shoes for, well, I did it for 41 years, and now I'm sitting here as the judge. The old, I can't help but feel a little humor about, way back when I couldn't even spell judge, and now I are one. So here we are. All right. Then does this take care of the matters for you today, Mr. Wilson?
Yes, Your Honor, it sure does.
All right. Then we appreciate your participation. Mr. Yanta, thank you.
Thank you, Your Honor.
Kayleen, I think we'll conclude that at this time. Y'all are free to leave the hearing.
Thank you. May I be excused?
Now, one question.
Yes,
The
sir.
witness list, have you gotten a specific witness list? Since it's been asked for, Mr. Yanta, I expect you will submit one.
Yes, Your Honor. The witness list deadline for the expert witness list per 3914 is 20 days prior to trial.
Right.
But all of our witnesses that the state intends to call are within the file and within the evidence turned over to the defense. But of course, we will also ask the arresting agency for any other evidence that they may have, just to re-urge the issue as it's part of its continuing duty, the state's continuing duty to turn over any Brady or Michael Morton evidence, Your Honor.
Very good. All right, then. That'll conclude the hearing. Thank you, everybody.
Thank you. May the state be excused, Your Honor.
Absolutely.